can you go into a little detail about what TDIU benefits entail and who's eligible for them?
Sure. The VA has this obscure regulation, 38 Code of Federal Regulations, Section 4.16. Dig deep enough to find that regulation. In there, you'll find two sections. Section A talks about what's called scheduler eligibility for TDIU. Section B talks about extra scheduler eligibility for TDIU. So let's unpack those a little bit. When the VA talks about scheduler eligibility for TDIU, they're talking about the ratings from the VA's combined ratings table. And on the combined ratings table, to be eligible under 4.16A on the scheduler basis, you have to have one of two things.
Welcome to the Victory Over VA podcast, a podcast about empowering veterans to overcome denied disability claims. Each week, we deliver critical insights to help you understand the disability process, veterans' benefits, and how to take control of your legal rights. Now here's your host, Attorney Francis Jackson.
Hello there. Welcome to our podcast, Victory Over VA, your guide to unlocking your disability benefits. If you're a veteran applying for disability benefits, subscribe for the latest developments in VA disability. So welcome all. I'm Francis Jackson. This is Kristian Terrison. We're from Jackson and MacNichol, a law firm that specializes in handling VA benefits and getting justice for veterans on their benefits claims. So what's this all about? Well, today we're going to talk about TDIU, which is an acronym for Total Disability Based on Individual Unemployability. You can see why they shorten it because it's such a mouthful. But that's our topic. And this show is obviously for veterans, but it's also for those who are concerned about veterans, whether you're a friend, a relative, or someone in the community helping to support veterans. This show is for you.
All right, well, let's get started. You explained TDIU is an acronym, but can you go into a little detail about what TDIU benefits entail and who's eligible for them?
Sure. The VA has this obscure regulation, 38 Code of Federal Regulations, Section 4.16. Dig deep enough to find that regulation. In there, you'll find two sections. Section A talks about what's called scheduler eligibility for TDIU. Section B talks about extra scheduler eligibility for TDIU. So let's unpack those a little bit. When the VA talks about scheduler eligibility for TDIU, they're talking about the ratings from the VA's combined ratings table. And on the combined ratings table, to be eligible under 4.16A on the scheduler basis, you have to have one of two things. You have to either have some condition, some particular condition that is rated at 60% or higher on the combined ratings table, or you can have a combination of conditions that are collectively rated at 70% on the combined ratings table, and one of those conditions, part of that combination, has to be rated at least 40% on the combined ratings table.
Now, I don't want to interrupt. This seems like a good time to talk about VA math, though, when it comes to combined ratings.
It is. VA math is not like ordinary math. In ordinary math, you take numbers, you add them up, you get the total. VA math works differently. Just to take as an example, if you have a rating of 50% for one condition, the VA starts by looking at the highest rating. So let's assume that you have a 50% rating that's your highest. So you take that and then say you have three other conditions that are each rated at 10%. So what the VA does is for each additional condition, in our case, three additional conditions rated at 10%, the VA takes 10% of the remainder. So if you already had a 50% disability, their theory is that you have 50% left. And so you take 10% of that, which gets you 5%, and they add that 5% to the 50%, and they round to the nearest 10% rating. So the 50 plus 5 gets you to 60. Then you add another 10%, which is now 10% of the remaining 40%, or 4%. So when you add that 4% with the already existing 55%, you only get to 59%. So you're still at 60, even though you have 50 plus 10 on the actual ratings. the combined table squeezes those together. And the next 10 is, 10% of that remainder. So it does at least get you to 70%. So it gets you to 70% because you've now pushed beyond, sorry, it doesn't get you to 70%. It adds up to over 60% because you've got the 50 plus 5 plus 4 plus 3. So you're still below the 65 threshold that would kick it up. So it's something you need to do with a chart to make sure you get it right.
And 70% is the magic number?
70% is the magic number for the schedule. And let me throw in that if you go on our VA website at veteransbenefits.com, you will find a calculator there that you can use to sort out the combined rating table. But going back to your question, 70% is the magic number, and that's because in our case we've got a condition rated at greater than 40%, so we've got that piece of it, and then we're going to have some additional qualifying conditions to add up to our 70% to get us to the magic number. But once you get to 70%, what happens then is that the VA concedes that you may be eligible for TDIU based on the schedule, and they look at the question of whether your service-connected disabilities in combination are sufficient to keep you from working full-time. Specifically, they want to know if you're working at above the poverty level or you're at what they call marginal employment, which is below the poverty level. And so that's how we get there. Now, the other half is 4.16b, which is not used very often, but the VA has the authority to look at the combined effects of all your service-connected disabilities. Keep in mind, they will not consider disabilities that exist but are not connected to service. You can have a terrible heart condition that keeps you from working, but if it's not connected to service, the VA is not going to consider it. But they look at all your service-connected disabilities, and they have the authority to recommend to the Director of Compensation and Pensions within the VA that you be given what's called extra scheduler TDIU, meaning you don't qualify on the schedule, you don't have a 60% or a 70%, including a 40% or higher rating, but they think that the combination of all your service-connected disabilities, in fact, keeps you from working. And as a result, they can recommend to the Director of Compensation and Pension that you be awarded TDIU on what's called an extra scheduler basis. Now, that's not something the regional offices do very often, but they can. And it tends to be where you have conditions that even though they don't rate highly on the schedule by themselves, they can have a significant impact. For example, if you have 2 bad shoulder problems, that's a condition that can make it very difficult to work because you can't use your arms effectively. Same with 2 elbow or wrist problems. Even though the ratings for those generally will not get you high enough to qualify on the schedule, they can be very, very devastating in terms of an ability to work. And the VA has the authority under 4.16b to recognize that.
Okay, and I wanted to ask a little bit about employment because that comes up very often when we're seeking TDIU in the cases I've worked on. Now, this is total disability for individual unemployability. Does that mean that all work is precluded when considering whether somebody qualifies for TDIU?
No, there are a couple of exceptions. The one that's, I think, most commonly seen is what's called marginal employment. And the VA generally looks at, as a measure of marginal employment, whether you can work at a level that at least meets the federal poverty level for a single person. I don't remember the number offhand, but it's around 17,000 at the moment. You can look it up online. But if you're working so sporadically or you're so poorly paid that you're working below that level, the VA will generally concede that is what's called marginal employment and will not count it in determining whether you're eligible for TDIU. Now, they may take it into consideration in kind of a backdoor way in that they may find that your disabilities, even in combination, don't really keep you from working, but they don't deny you specifically based on low-paid employment that is below the federal poverty level. They recognize that's marginal and shouldn't be considered.
So for a veteran who's applying for TDIU, what types of evidence are most persuasive?
Generally speaking, vocational evidence is most persuasive, and that can be from a couple of different sources. The VA has its own internal vocational rehabilitation program, and so reports from those folks are very helpful. Alternatively, a private vocational consultant can provide very useful information. We've worked with several around the country who have expertise in vocational rehabilitation. These are usually folks who work with state-level vocational rehabilitation organizations or insurance companies doing placement for people who've been injured. Often they're folks who are applying on workers' compensation after an injury. And if that injury is a service-connected injury, it may tie into TDIU. But the point is that these folks have expertise in the impact of various injuries, illnesses, and disabilities on the ability to work, and can provide very helpful information to the VA to help them understand why your particular combination of service-connected disabilities makes it impossible for you to work.
And for a veteran who's currently working but really struggling due to a service-connected disability, what would your advice be to them?
Well, it's sort of in two parts. First, even if folks are struggling, my personal bias is that if you're able to work and support yourself and get the benefit of having a regular paycheck and having some social interaction with other workers and having a place to go and a purpose to go there, then you're probably better off to struggle along if you can. But unfortunately, for many people, there comes a point where they can't, where the pain or the limitations in their physical abilities reach a point where they simply can't effectively continue to work. At that point, as soon as that happens, you should file an application for TDIU if you have a qualifying combination of service-connected disabilities, or you think even if you don't qualify on the schedule, the combined effects of your disabilities are such that you're not able to work. The sad cases that we see sometimes that don't qualify for TDIU are folks who have a non-service connected disability that is really the primary reason they can't work. I think I mentioned an example a little while ago, someone who has a bad heart condition which is not connected to their service and really precludes them from working. Their service-connected disabilities might be relatively minor and that person won't qualify. But you can have a very serious non-service connected condition and still qualify for TDIU so long as your additional service-connected conditions, even without consideration of the non-service connected conditions, is enough to stop you from working.
And earlier you had mentioned a little bit about marginal employment and how veterans with marginal employment can still qualify for TDIU.
Yep.
Are there other circumstances under which a veteran can still be doing some work but qualify for TDIU?
There are. The other circumstance is what the VA considers to be sheltered or accommodated work. And essentially, the VA recognizes that most in the family context. You know, if you're working for your brother and he lets you go home early whenever you don't feel good, or he makes special accommodations to let you work from home in a job that anybody else would have to be in the building for, that sort of thing, then the VA will look at kind of the level of accommodation. And if you have a lot of accommodations that simply would not be extended to an ordinary employee, then the VA may recognize that is so heavily accommodated that it's equivalent to not really being able to work, and you're only able to work because of a special relationship with a friend or relative that's letting you do this job. It doesn't have to be a friend or relative, however. It can just be a very forgiving employer who keeps you on for whatever reason. Sometimes we see that in the context of people who have some very special expertise, and even though they don't do many of the things that would ordinarily be part of the duties for that position, the employer recognizes that they have such specialized expertise that they will accommodate them in ways that would just not be available in the ordinary labor market.
One thing that I'd seen in a few of the cases I'd worked on too was folks who worked in some capacity for their church as a sextant or doing some like clerical work, things like that. And the setting was such that They recognized that there were serious medical conditions and they could call out when needed and things like that. So,
Yep, any situation where the person is being given special accommodations and treated differently than an ordinary employee doing that job in a typical work setting can be considered. Now, these accommodation cases are totally fact intensive. It's all about how would an ordinary employee do this job and how is this person doing the job and what are the differences that are being allowed them. But it is possible in those circumstances to sometimes demonstrate that the accommodations are so extensive that no other employer would ever do this and the VA shouldn't consider it. But those are always very fact intensive and it's an uphill stretch. There's an interesting case from a few years ago that the Chisholm firm in Rhode Island had, and a fellow worked in a construction company. It was a family-owned business, and he had a serious mental health issue, just was not able to control his behavior around others very well on multiple occasions. And any other company would have fired him when he got into these altercations with customers and workers and so on. But because it was a family business, they would just go back to the client or the worker and say, you know, it's Jimmy, he's got some problems, please let that slide, you know, we'll take care of it. And they got him an award of TDIU, even though he was a very well-paid employee because of the special circumstances.
and this is actually a genuine question. Oftentimes when I'm asking you, I'll know the answer, but I wanted to ask how the VA's view on self-employment and entrepreneurship as concerns TDIU. I worked on one case where I was able to successfully argue it, but the earnings were low enough that it wasn't anything extraordinary. But I know there are other folks out there who may be making quite a substantial bit of income despite not being able to be an active participant in the business due to a condition.
Yeah, the VA, generally speaking, looks at those in terms of whether it's marginal employment. If it's above marginal employment, that's going to be a very tough sell. But what I have seen is a person who had an ownership interest in the company was not being paid a significant salary because they weren't actively doing much, but they did have an ownership interest and got significant money as dividends from the company. And the VA still granted the benefit. You know, again, those are so fact intensive that you can't offer a general rule, but it's a possibility. That's all I can really say safely.
Sure. And how about an attorney's role in supporting a veteran who's applying for TDIU? Because I know there are many moving parts and lots of documentation to gather up, but what would some of the ways an attorney could help be?
I think it's like most cases where an attorney can help. It's all about marshaling the facts in most cases. The problem is that most veterans are not schooled in the law, and they don't understand the VA regulations. They wouldn't know even where to start in terms of recognizing what's marginal employment, what's not, whether a job is accommodated or isn't. And so unless TDIU is very straightforward, and there are cases where it's very straightforward, the person has a high rating on the schedule, is obviously unable to work for physical or emotional reasons, and the VA can just see that and grant it. But there are lots of cases that are right on the borderline. Either the person is working, but when you pull together the numbers, it's actually marginal employment. For example, I had a case fairly recently where the fellow's income, as he reported it to VA, was quite high. But when you dug into the facts, what was going on was that he was reporting to them his gross income. He was self-employed. He had considerable expenses. When you deducted the expenses from the gross income, his actual net earnings were marginal employment. But he didn't understand how that all worked, and when they asked him what he was making, he just gave them the gross number. This is the amount of money that came into my hands last year. But that isn't really the question. The question is, what was the net that you were able to keep and pay taxes on? And that was much lower.
We're coming to the end of our time for today, but I wanted to ask specifically about the process for applying for TDIU and how it's different from other types of claims, like for a specific medical condition or disability.
Sure. Well, the answer is that the VA requires you to apply for TDIU on a special form. It's called 8940 form. And it requires filling out information about past employment. And one reason that having an attorney is very helpful on those is that the form is very confusing to most veterans. The form asks for the information about your last 5 years of employment. What most veterans don't understand is that it doesn't mean your employment in the last 5 years. It means the last 5 years you were employed. So if you haven't worked in 10 years, they want to know about the work from 15 years ago. They don't want to hear that I didn't work in the last 5 years. And I can't tell you how many veterans have sent us back a form that just says, I didn't work in the last 5 years. And we have to go back and explain to them, no. They want to know what you did, where you worked, what the job was, how much you made in the last 5 years before you stopped working. The form is very poorly worded and it throws people off all the time. The other tricky part about applying for TDIU is that the VA is actually not supposed to require you to submit the form. They're supposed to consider TDIU whenever there is evidence that you're not able to be employed because of your service-connected conditions. But they get that wrong all the time. It is amazing to me that the folks who are supervising the regional office staff cannot seem to get it across that they have to consider TDIU regardless of whether you file the form. In case after case where we ask them to consider TDIU, they say, well, you haven't filed an 8940 form, and you got to file that form. Well, you don't have to file the form. But if you don't file the form, you're going to have 5 years of fighting about it. So you're better off to file the form. And then when they say, well, we can only give you benefits back to June 1st when you filed the form, you say, no, that's wrong. He was eligible for TDIU all the way back to 6 years ago when he got his 70% rating. And we know he didn't file the form, but it's not required, and you have to consider it all the way back. And they just never seem to get that right. Lots of cases where we have to file some sort of appeal, whether it's higher level review or even appeal to the board, just to get the date right. But you can get it right eventually if you try.
All right. Well, this has been another episode of Victory Over VA. Thank you for tuning in. Please be sure to subscribe, and we'll see you next week.
Take care.
Thanks for joining us this week on the Victory Over VA podcast. Make sure to visit our website, veteransbenefits.com/podcast, where you can subscribe to the show in iTunes, Spotify, or via RSS, so you'll never miss a show. While you're at it, if you found value in this show, we'd appreciate a rating on iTunes, or if you'd simply tell a friend about the show, that would help us out too. If you like this show, you might want to check out our free consultation to see how we can help you with your denied claim. Simply go to veteransbenefits.com and fill out the form. You fought for us. Now let us fight for you. And be sure to tune in next week for our next episode.